Okay, good afternoon, everyone, and welcome to our Gaza lecture series. This is co-sponsored by 4 different units on campus: the Center for Muslim Christian Understanding, the Center for Contemporary Arab Studies, our African Studies program, and our campus in Doha, Qatar. It's a huge honor to introduce Dirk Moses to you today. Dirk Moses is the Anne and Bernard Spitzer Professor of Political Science at City College of New York. Previously, he held a distinguished professorship at the University of North Carolina in Chapel Hill, and he's taught at the University of Sydney and the European University Institute in Florence, Italy. He's the author of numerous important publications on genocide and international affairs, most recently, The Problem of Genocide, Permanent Security and the Language of Transgression. His anthologies include The Russian Invasion of Ukraine, Victims, Perpetrators, Justice, and the Question of Genocide, 2024, and Patriotic History and the Renationalization of Memory in 2023. He is the senior editor of the most prestigious journal of genocide studies, the Journal of Genocide Research, where he's also running a special forum in that journal on the question of Gaza, and his public writings on Gaza and Ukraine have appeared in the Boston Review, Noma Magazine, and Lawfare. This is Dirk Moses' official biography. I like to describe Dirk Moses as a pioneer in the field of genocide studies. He is an original, provocative, and courageous scholar. His very close reading of the collected writings of Raphael Lemkin, the founding figure in genocide studies, has revolutionized the study of genocide by infusing it with historical depth and deeper ethical content. Professor Moses' prodigious and exemplary efforts to excavate the history of genocide by illuminating the relationship between empire, colonialism, and genocide has been both path-breaking and very influential. As he writes in the preface to his important edited volume, Empire, Colony, and Genocide, Conquest, Occupation, and Subaltern Resistance in World History, a transnational approach of comparative colonialism and genocide studies helps us to uncover the colonial roots of the genocide concept itself and to operationalize Raphael Lemkin's original but ignored insight that genocides are intrinsically colonial and they long precede the 20th century. Of course, this observation is especially powerful and poignant today, given US support for Israeli policy in Gaza, which all of you now know is being investigated by the International Court of Justice as a plausible case of genocide. And since we're at a Jesuit university, I should also mention that last week, Pope Francis has weighed in on the topic of genocide in Gaza, where he said, quote, "It should be carefully investigated by experts to determine whether it fits into the technical definition of genocide formulated by jurists and international bodies." One of those experts is with us today. Given his important contributions to this topic, it's a huge honor to have Dirk Moses included as part of our Gaza lecture series to lecture on the topic, the concept of genocide and the destruction of Gaza. Please join me in welcoming him to Georgetown University today.
Many thanks for the generous introduction, Nada. To address you in this lecture series, it's an honor to be here and part of this distinguished series devoted to Gaza. Hope you can hear me in the back because there's no mic up here. Okay. The suffering of the civilian population in particular is uppermost in my mind. And it's one of the reasons I've devoted my scholarly work to studying genocide and mass violence against civilians generally for the last quarter of a century. Finished my PhD in the year 2000. And I'm sure I'm not alone in this respect. In addition to a universalistic commitment to human rights and civilian protection, which necessarily applies generally and transcends specific conflicts, we also bring our particularistic commitments as nationally defined subjects. It's no accident that in my first book, which was an anthology, I treated genocide in Australia, my homeland, 20 years ago. That is, on the genocide of indigenous peoples by the settlers. It's the red book on the left, whose cover is taken from a plaque of a memorial to a massacre of indigenous peoples in 1838. As a settler Australian, my analytical lens has always been attuned to the colonial dimensions of genocidal situations, Hence also that second book, the blue one in 2008, which Nada alluded to, an anthology that includes a chapter, say, on the Russia's imperial conquest of the Caucasus that was taking place at the same time as this massacre in Australia in the 1830s and 40s. These temporal coincidences, ones like this, have led me to a global and comparative as well as colonial approach to the subject. These massacres took place in the context of imperial expansion, after all. As we'll see in the course of this paper, these colonial imperial dimensions are intrinsic to the concept of genocide itself. Unfortunately, genocide is in the air. Our meeting here coincides with the 30th anniversary of the Rwandan genocide in 1994, in April. Claims of genocide in Ethiopia, now Myanmar, since 2017, in China, last 10 years, in relation to the Uyghur people in Xinjiang province, and now, of course, in Gaza, in addition to Ukraine. It's also the 25th anniversary of the establishment of the Journal of Genocide Research, which, as you heard, I've been editing, in fact, for the last 12 years. Last year, we published a double special issue on the subject called Of the Russian Invasion of Ukraine. That's what they look like, these special issues. And then it appeared as a book just a few months ago. And I don't claim to be an expert on Ukraine, but you'll see that my co-editor is one of your colleagues, Diana Dumitru, who I believe holds your Romanian history chair. Okay, I'll be seeing her this afternoon. We'll have a chat. Now we're doing an extensive forum on Gaza, and it too will appear, I think, as a book with Routledge, which is the publisher of the journal. Genocide has been alleged in the full-scale Russian invasion of Ukraine. Eugene Finkel, who teaches at Johns Hopkins, the one in Bologna, has written many essays to this effect and has a book coming out on the subject. The Intent to Destroy, a quote from the Genocide Convention, Russia's 200-year quest to dominate Ukraine. It doesn't say to destroy Ukraine, to dominate. We'll get back to that. We'll keep that in mind as I move through the slides. Of course, Ukrainian jurists have weighed in, as in this detailed piece in the Journal of International Criminal Justice a year ago, understanding Russia's actions in Ukraine as the crime of genocide. However, the International Criminal Court, the ICC, has not followed suit. It has issued a warrant against Vladimir Putin and the Commissioner for Children's Rights in the Russian Federation for the war crime of unlawful deportation of population children, and that of unlawful transfer of population children from occupied areas of Ukraine to the Russian Federation. Now, as many of you know, transferring children from one group to another is also covered by the UN Convention on the Punishment and Prevention of Genocide from 1948. I commissioned and published a long article in the Journal of Genocide Research by the Ukrainian jurist Yulia Yoffa, showing how Russia's actions fall within the convention regarding child transfer. And yet the ICC ignored that and decided to go with war crimes. The ICC has done the same for Israel's conduct of its campaign in Gaza, despite arguments by many that Israel is committing genocide. In fact, when the warrant was finally approved by the pre-trial chamber, after months of waiting, just a week ago, it dropped the reference to the crime of humanity of extermination, which was in the original application from May this year. So it's actually kind of pared it down. And the crime against humanity of extermination is as close you can get to genocide within that rubric. Now, as a scholar, I'm uninterested in adjudicating whether genocide is taking place. I'll disappoint the Pope, who's looking for scholars to adjudicate. You need international lawyers to do that. And I'm an historian and international relations scholar. The temptation, though, I want to add, why I'm reluctant to do this. The temptation is great for scholars who are, in the end, relatively insignificant people in the grand scheme of things, to strike the pose of the truth teller or the moral hero who will declare whether this or that genocide is definitively a genocide before an expectant audience who was looking to their expertise. This expectation can appeal to their moral vanity and thereby short circuit, and I know scholars who've succumbed to this, though I won't name them though. Succumbing to this temptation short circuits the critical questioning that I believe is the role of the academic, at least in the social sciences and the humanities. While the lawyer is tasked with prosecuting a case for a client, is it genocide, yes or no? It's a very simple. The scholar's job in the international relations, say, is different. It does not need to take the law and its animating concept, say genocide, as given. It can ask, why is so much emphasis placed on the claim? Why is genocide the crime of crimes, as it is called? Why are war crimes and crimes against humanity, which featured in the Nuremberg trials after World War II as the ultimate transgressions, rather than genocide, seen now as lesser charges? Why this hierarchy in perceptions of international criminal law and in our imagination of evil? For reasons we can discuss, genocide has become a synonym for absolute evil, capital A and capital E, entailing utterly evil perpetrators and utterly innocent victims. I believe this, what is really a theological template, draws on archetypes buried deep in our imaginations that are recruited when trying to explain immense suffering and its causes. And I think at a Catholic university like this, it's okay to talk about these theological dimensions. I actually did a master's at Notre Dame, so I feel I'm licensed to as well, though I didn't grow up Roman Catholic, Anglo-Catholic. Genocide also addresses collective identity. It's an attack on collective identity, not just on a civilian population, as in the case of crimes against humanity. Genocide carries a stigmatic aura with biblical connotations, a people disappearing from history. In all the legal discussion about the ICC and the International Court of Justice, the ICJ, we don't talk much about these subterranean imaginaries of evil, but I think we should, because I see them activated in the urgency around the topic. As a result of this hierarchy, genocide is the crime of crimes. Where people cannot see genocide, they are less shocked by mass violence against civilians. And I think this is a problem, because this preoccupation with genocide inadvertently licenses non-genocidal civilian destruction by distinguishing artificially between their driving logics. Genocide is caused by ideologies of hatred in which racialized victims are targeted as such, as the Genocide Convention puts it, on the one hand, versus military targeting in which civilians are killed collaterally or incidentally on the other. The former, genocide, is stigmatized and criminalized, while the latter is usually legal and quickly forgotten. And that's why advocates for Ukraine and Palestine fixate on genocide, as other victims have before them. We are dealing here with a basic distinction in international affairs between armed conflict and genocide, the former motivated, according to this theory, by the imperative to defeat an enemy, its enemy forces, not its civilians, when the killing is supposed to stop. And the latter, genocide, is driven by the logic to destroy an enemy, including its civilians, as an end in itself. Let us not forget that armed conflict warfare is not illegal according to the UN Charter if carried out in self-defense, in effect as a just war. Self-preservation has been the basic prerogative of states since time immemorial. In the past, few limitations applied to state conduct when it felt its existence is imperiled. Now, international law insists that just wars are fought justly, meaning that principles of distinction, precaution, and proportionality are observed. If civilians are killed disproportionately in targeting military objectives, war crimes may be committed. If attacks on the civilian population are widespread or systematic, we are talking about crimes against humanity, but not genocide. That is reserved for the intention to destroy an ethnic, racial, or religious group in whole or in part as such. I think the distinction, which was crystallized after World War II, is deeply problematic. And I think your previous speakers, admirable as they are, have taken this for granted. And they said, well, this now looks like a genocide for me. So they've sort of bought into the existing architecture of international law and our perceptions of evil. Unfortunately, we miss the problematic nature of this distinction if we play the game of genocide ascription or attribution. I think the lawyers can play that game in international courts, but we don't have to here. We can think it a little more deeper. I think it's time to be self-aware about the legal regime we inherited from the 1940s and how it organizes our moral perceptions. I will begin how and why. I will explain how and why this came to pass and how it works in this paper, briefly, obviously. Right? There's a 500-page book I've written about this if you want to get into more detail. In doing so, we'll understand, I hope, why the quibbling and wrangling about the definition of genocide is inherent to its constitution. The UN Genocide Convention, I argue, did not mark some momentous humanitarian step forward as commonly supposed. For the states that thrashed out the convention in 1947 and 48, designed it so that state sovereignty would not be compromised in waging international and non-international armed conflict. The convention criminalized only a very narrow and virtually impossible to prove modality of mass violence, which was then elevated to the crime of crimes, meaning other modes of state violence were lesser crimes. And the courts since the 1990s have restricted the definition even further, making genocide so difficult to prove. And that is, I believe, why the ICC is not including genocide in its indictments against Russians, Palestinians, and Israeli leaders. Let's not forget that the ICC issued an indictment for a Palestinian leader as well, though he's likely dead. Let us recall that states negotiating the convention, as I've said, did not regard warfare as illegitimate. They had just defeated the Axis powers, destroyed their cities with fire and atomic bombs, and countenanced the forced expulsion of 12 million ethnic Germans from East Central Europe. Ethnic cleansing had occurred in South Asia and Palestine, while the UN Convention negotiations were underway. The Cold War was beginning, and independence movements confronted the Western colonial empires reasserting control in Asia and Northern Africa. For the war's victors, Western states and the Soviet Union, the sovereign right of states to engage in armed conflict required the rescue of military necessity from its discrediting by the Nazi mode of exterminatory warfare and occupation. Everyone understood that armed conflict impacted civilians dramatically. The official committee of experts commentary on the draft Genocide Convention, it went through various drafts, written in part by the Polish Jewish jurist Raphael Lemkin, who had coined the term genocide during World War II to describe the Nazi extermination campaigns, acknowledged in this commentary that civilian populations were affected by modern warfare, quote, with more or less severe losses. So it distinguished between armed conflict and genocide by arguing that in genocide, quote, one of the belligerents aims at exterminating the population of enemy territory and systematically destroys, and this is the key phrase, what are not genuine military objectives, unquote. Military objectives, by contrast, aimed at imposing the victor's will on the loser, whose existence was not imperiled. After all, German cities were flattened, but there were still tens of millions of Germans at the end of the war, and Germany as such was not imperiled. And that analogy is made today in relation to Gaza. Now, killing masses of civilians was acceptable according to this reasoning, if regrettable. when motivated by military goals. Victory, not destruction. Let us also recall the original definition of genocide developed by Lemkin during the early 1940s, when he sought to enter the international debate about proposed post-war trials of Germans. In his book, Axis Rule in Occupied Europe, this was on the right on the slide, he did so in broad terms, declaring that the distinction between civilians and combatants was elemental to the crime of genocide. This is what he wrote. Genocide is the antithesis to what he called the Rousseau Portalis doctrine. You don't need to know that. But the point is implicit in the Hague regulations. He's referring to the Hague Convention of 1899, 1907, which governed the occupation of enemy territory during peace negotiations after a war and the treatment of POWs. This doctrine, he continued, holds that war is directed against sovereigns and armies, not against subjects and civilians. In its modern application in civilized society, the doctrine means that war is conducted against states and armed forces, not against populations. So bear that distinction in mind as we transition later in the paper into the concrete case of what's going on in Gaza. Is what is going on in Gaza a war against Hamas, that is the para-state there and its armed forces, and not against its civilians, its population? Can it be distinguished so easily? Now here in this statement, Lemkin promisingly declared that criminality was defined as warfare waged against populations rather than armies. Today, customary international humanitarian law refers to the principle of distinction between combatants and non-combatants. Genocide was not at this stage in his thinking, not separate from war. It was a kind of warfare, but against the civilian population, as well as its armed forces. In other words, it was a kind of warfare against an entire nation. Are we seeing that in Ukraine and in Gaza today? Question mark. Genocide also attacked, he continued, all elements of nationality. Lemkin drew on the publication in formulating his theories, the Polish, Czechoslovak governments in exile, which were in London, to develop his notion. Consider the table of contents from two of these books by these governments in exile. Here is the book, The German New Order in Poland, 1942, by the Polish government in exile. Notice the table of contents and the imagination of the generalized attack on the nation in its different dimensions. Massacres, expulsions, persecution of Jewish citizens in Section 1, Section 2, pillage and exploitation, and in Section 3, an attack on culture, the struggle against the Polish spirit. It's the kind of language they use. I mean, this is the first half of the 20th century, a very nationalistic time. So Polish patriots, Lemkin among them, will talk about the soul of the Polish nation, or the soul of the Jewish people. It's like, today we talk more about culture. We see the same pattern in the Czechoslovak book. This is a screenshot, it's a bit fuzzy. I hope you can see it. From 1941, Conquest, the persecution of Christians and Jews, economic enslavement, destruction of culture, the crushing of resistance. Today, we are seeing the proliferation of terms like scholasticide to refer to the different elements of group life in Gaza. The identification of these elements, although disaggregating in a way you can destroy a group, was occurring already in the 1940s, as you can see. Lemkin also drew on the Institute for Jewish Affairs in New York, a research outfit staffed by exiled scholars from Eastern Europe, funded by the World Jewish Congress, who produced a stream of very influential and impressive publications, which covered every aspect of the Nazi occupation of different European countries, and its effects on their Jewish populations. Note the title of these books on which Lemkin drew. The one on the left, it's called The Racial State by Gerhard Jacobi, is about the Nazi occupation of Czechoslovakia. In this book, he refers to it as, in fact, colonial, because it was a protectorate kind of language in the history of empires, right? Noting that the Germans were treating Czechoslovaks like non-European colonial peoples. There's a notion taken up by Césaire and others just a few years later. It was a very common idea at the time and not particularly controversial. And now, if you say these things, you might lose your job. Will appear on the Canary Mission website. The book on the right refers to starvation over Europe made in Germany. And it's referring to the Jews in Polish ghettos, or ghettos in Polish, on the edge of in Polish cities, which at the time of writing was the main cause of mortality. It's before there was consciousness and awareness of the camps. Now, to underline the colonial aspect, Lemkin defined genocide in these terms as well. So in his sense, was reflecting a common discourse at the time that the Nazi empire was, you know, an empire, and that it was settling its civilians, its German nationals in East Central European countries after decimating the Slavic population and deporting and exterminating the Jewish one. Lemkin was reflecting that in a sort of legalistic mode and in this concept of genocide. So he wrote, genocide has two phases. One, the destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. This imposition, in turn, may be made upon the oppressed population, which is allowed to remain on the territory alone after the removal of the population and the colonization by the oppressor's own nationals. So he's referring very much to the process that he observed happening in East Central Europe. Now, those of us interested in settler colonial contexts like Australia, about which I did my first book, seized on these statements 20 years ago or so, which had been ignored by older generations of genocide scholars. We also noted this very broad statement defining genocide thus. This is in the same chapter. Genocide is chapter 9 of this book, Axis, Rule, and Occupied Europe. The chapter before chapter 8 is on the specific situation of Jewish people in Europe. So this is how he defines genocide. It should be, as he argued, an amendment to the Hague Conventions. At that time, he wasn't thinking genocide would be a separate convention. That was impossible for him to imagine in the early 40s, 43, 42. He thought, let's update the Hague Conventions. We have international law. Let's add the destruction of nations in there with the word genocide, because the Hague Conventions couldn't foresee the radicality of the Nazi occupation. It was written in 1899. Okay. He said, we need to augment these Hague Conventions thus. In the first should be included every action infringing upon the life, liberty, health, corporal integrity, economic existence, and the honor of the inhabitants when committed because they belong to a national, religious, or racial group. And in the second, every policy aiming at the destruction or aggrandizement of one such group to the prejudice or detriment of another. So it's not just destruction, it's aggrandizement. And in other parts of his work, he used the word crippling. So genocide was destruction or crippling. Okay. So an extremely broad definition. Now, drawing on these books I mentioned before, Lemkin then articulated genocide into different techniques, we would say today, policies, that reflect the multidimensional nature of collective life. And that reflected his experience of small nations membership in this part of the world, nations sandwiched between large empires in this zone between the Baltics and the Black Sea. I don't know how many are familiar with this notion of the small nations of Europe, right? This is the zone that Timothy Snyder called the Blundlands, of course. These nations, Poland and Ukraine are not physically small nations, they're tens of millions of people. But compared to Russia and to Germany, smaller. And the notion refers very much to the mentality of precarious nationhood, because, of course, Poland disappeared from the map from its partitions at the end of the 18th century to reappear at the end of the First World War. The Baltic states, for the first time, their nationhood, Czechoslovak, was spun out of whole cloth by Seton Watson and other English scholars who advised the British Foreign Office. In any event, these cultural nations, as Meinecke put it, suddenly found themselves having statehood and sovereignty, and obviously extremely anxious to maintain this hard-won autonomy and sovereignty. And it's led to a whole range of unpleasant policies to their minorities between the wars. But the sense of precariousness is what Lemkin is capturing with the notion of genocide. You want to protect this nationality which is threatened. Nations, he argued, along with everyone else at the time, were cultural as well as biological entities. They required political institutions and natural resources to reproduce themselves. Hence, this articulation of the genocide concept into its different elements. Lemkin, who believed in nations as spiritual entities and was himself a nationalist, a committed Zionist, as the historian Jim Leffler has shown, invented this concept to reflect this multidimensional nature. However, Lemkin also defined genocide so broadly for a political contingent reason. When he came to the US to escape the Nazis in 1941, working at Duke University as an adjunct, which at the time I think was called Trinity College, or it's a very religious sort of Methodist place. I used to visit it a bit when I was at UNC, the cathedral in the middle of the place. He saw that Americans regarded the Nazi regime as above all an anti-Christian empire. It's hard for us to understand now, but if you read the press coverage at the time, and Deborah Lipstadt's first book, by the way, was on the American press coverage of the Holocaust. And she showed that, the persecution of Jews wasn't completely omitted, but, you have to see where it is in the newspaper. You have to pull up in the New York Times, and on page 8, there's a single column. So there's not front page news, whereas the rest of the military campaign is front page news. And the notion that this was an anti-Christian pagan empire that was destroying the Christian nations that it occupied. It was obviously, Christians were the overwhelming majority of the population of Europe. The persecution was noted and regretted, but was not the main focus. In fact, a very marginal focus. And he believed that he could direct attention to the Jewish fate if the Christian and Jewish destinies were linked through in equal urgency. And his notion of genocide, I think, was a bridging concept. The destruction of the Polish, he was also a patriotic Pole, the destruction of the Polish nation via these measures we saw, but which left the vast majority of Polish people alive. This notion applied then equally to Jews in Europe, who the Nazis wanted to exterminate entirely. Now, you have to ask yourself, does this conceptually make any sense? In other words, genocide, as he defined it, encompassed persecution, so crippling, aggrandizement of one people over the other, with extermination in one concept. And that's why I think it's inherently unstable. Now, this is not what international law ended up becoming. Okay? The concept of genocide in this version, its original version, was unacceptable for states in the UN negotiating the convention in 1947 and 48. As I've already mentioned, most states wanted to be able to put down domestic opposition, assimilate minorities, and wage wars as they pleased. And as I've already mentioned again, I've considered the Allied use of aerial bombing, including the US's views of atomic bombs, without falling foul of an international treaty and interference by an international court like the ICC. So they pared down Lemkin's definition drastically to separate genocidal and military logics. Although I think, and as I'll show, in practice, it's very difficult to do so. Now, how did the UN Convention affect this distinction? I don't know if you can read that at the back. This is a screenshot of the original. First, it states that genocide must be the intent to destroy in whole or in part national, ethnic, racial, or religious group as such by various means. As such, requires that victims are targeted solely on the grounds of their identity for symbolic rather than material reasons like warfare. The states negotiating the convention's definition deliberately modeled it on the Holocaust as extermination, understood as history's largest hate crime, to distinguish it from warfare. The convention thus omits cultural genocide, population transfer, which the Western powers had been complicit in at Potsdam and Yalta, political groups and motivations, and it limited genocide to the biological destruction of these groups to resemble the Holocaust, and then it elevated it to the crime of crimes. Over the next decades, while genocide was elevated to this status, it was also being depoliticized by being understood as a murderous attack on a people solely on the basis of their hated group membership, merely for who they are, not for anything that they have done. Based on this archetype or ideal type, the Holocaust, understood as history's largest hate crime, in which Jews were killed simply for being Jews, not for anything they had done. After all, there'd been no Jewish uprising. There'd been no Jewish October 7th against the Nazis, right? Repressing political opposition and targeting entire peoples in warfare as a consequence was now all the easier because the Holocaust analogy was so difficult to make after the war when civilians have been victims of armed conflict. As a consequence, the wars waged ever since, so since the late 40s, in which many millions of civilians have died, have not been categorized as genocide. Between the late 60s and 70s, for instance, an intense global debate, and I go into detail on this in another paper, we don't have time, was undertaken about whether genocide had occurred in Vietnam, in the civil war in Nigeria, the Biafra secessionist war, and in the secession of East Pakistan to create Bangladesh in 1971. Many millions of people perished in these conflicts, far more than in Palestine, Ukraine, or Sudan today. Despite the advocacy of the victims at the time, they were deemed to be messy armed conflicts in which civilians unfortunately perished. They did not resemble the Holocaust, it was argued, and they were thus not genocide. The same debate continues today, and I fear the same outcome. But like the ICC, the ICJ, which will hear the merits of the case brought by South Africa in the next year or so, the wheels of justice turn slowly, will determine that the primary context here is an armed conflict in which the pursuit of military goals by Israel accounts for most of the killing. Let's not forget that the ICC warrant against the Israeli leaders focuses on the policy of starvation, when most of the Palestinian deaths have been caused by bombing. We'll get back to this later in the paper. Now, does this distinction between armed conflict and genocide as very separate categories make sense? If you press this distinction between military and genocidal violence, it's theoretically very tidy. One is aimed at destruction, the other at defeat. I do think, though, it's nonsensical in practice. As we see in Gaza today, the Israeli mode of warfare has destroyed the Strip. Apart from the death toll, we see the destruction of buildings, institutions of all types, schools, mosques, hospitals, etc., and of agriculture, making the reproduction of life all but impossible. The reports of the Special Rapporteur of the Occupied Palestinian Territories, Francesca Albanese, has the three she's written, have highlighted this destruction very much in a Lemkin spirit. If you read those reports, she sort of separates out each element, much like these table of contents from the Polish and Czechoslovak governments in exile, and like Lemkin's chapter 9 on the techniques of genocide. Her last report is called, whoops, I have to go back a bit, Genocide as Colonial Erasure. The new report by Forensic Architecture indeed explicitly invokes Lemkin's original broad definition of genocide in its report, The Cartography of Genocide. You can see their table of contents: destruction, spatial control, displacement, destruction of agriculture and water sources, destruction of medical infrastructure, civilian infrastructure, targeting of it. It's not the exact same table of contents as those ones from the early 40s, but the style of reasoning is the same. They show accurately, I believe, and I think what is blindingly obvious to any fair-minded observer, is that Israeli authorities have destroyed Gaza, even if not exterminating the entire population. This is what Lemkin was getting at. Destruction is broader than extermination. That's why I didn't use the term extermination. But the law largely, as we know, reduced destruction to extermination, and it legitimated military logics to defeat if carried out in self-defense. And that is why you hear so much about Israel's right to self-defense by its backers, and why the ICC warrants alleging war crimes and crimes against humanity argue that the starvation policy has no military purpose. If it had a purpose, a military purpose, it would not be a crime. The Geneva Conventions allow sieges and blockades. Let us not forget. Now, this is very small, so I'll read it out for you. Military necessity excuses a lot of civilian destruction. So, I'm just going to read the first one. This is cut and pasted from the database of the ICRC. Sieges that cause starvation. The prohibition on starvation as a method of war does not prohibit siege warfare as long as the purpose is to achieve a military objective and not to starve the population, which is what Israel will allege at the trial if it ever comes to that, right? I mean, that's an extraordinary statement, right? It's okay to starve it's okay to starve through siege warfare if the purpose is military. Now, let's look at the second one, blockades and embargoes that cause starvation. Likewise, so this is cut and pasted. This is not my typing, right? I just cut and pasted this from the website. Likewise, a prohibition on starvation as a method of warfare does not prohibit the imposition of a naval blockade as long as the purpose is to achieve a military objective and not to starve the civilian population. So what the judges at the pretrial chamber concluded is that they're not convinced that what's happening is driven by a military objective. There's certainly the term, there's the typical language of lawyers say, we conclude on reasonable grounds, that kind of. In other words, let's go and take a look at a trial. We're convinced that there's enough of a case to answer, but they haven't, we need to have the trial. At the trial, the Israeli lawyers will argue that we weren't trying to starve the population, we were trying to starve Hamas. Okay. Bear that in mind because I'll return to this. Now, I have to backtrack a bit because I got it out of order. Now, I'm going to just walk through these slides without text. Why is this ICJ standard of proof of mens rea, the intent to destroy, so difficult to prove? Here's a little article about it, and there's lots of them online, but this one is very pithy by Brishna Gehani on the Research Society for International Law website. And I'll just have some quotes here. The ICJ requires that a state must have dolus specialis, or a special intent, to commit genocide. This criteria can only be fully satisfied or satisfied if the evidence is fully conclusive. So these are quotes from the trials, okay? Or from the judgments by the previous cases of the special intent to commit genocide. Fully conclusive is a very high standard of proof. In the only judgments handed down in genocide cases by the ICJ to date, the ICJ held that this standard has not been satisfied. The dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly stated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such an intent. In other words, a genocidal intent, not a military intent. You can't have mixed intent for the ICJ. It's got to be one or the other. If Israel at the merit stage, so when it comes up for trial, illustrates that its pattern of conduct was not to harm Palestinians, but to destroy Hamas, which Israel most definitely will argue, then Israel's pattern of conduct since 7th of October would not be fully conclusive to show that Israel committed a genocide of the people of Palestine. This is how high the standard of proof is. And when she finishes that article, she's kind of shocked. It's like, well, some of us are like, yeah, we've been trying to tell you, right? The historians among us think that the law is designed like that to thwart victims. Now, I do understand the impulse to reach for the genocide claim. All victims of mass violence and persecution do so. Consider the Rohingya from Myanmar, Uyghurs in China, Armenians before them. Among them, of course, many others. The rules of recognition are set, and victim groups have no alternative but to play the game. My point is that the rules are biased against you because they buy into the artificial and misleading binary between war and genocide. Rather than engage in years of yes or no, rather than engage in the yes or no calculus that the law of genocide demands, the novel nature of the Israeli campaign can call for rethinking of this artificial binary between war and genocide. Because this war we're seeing today fuses their logics in various ways that international courts could register in reconsidering how they deduce mens rea, this mental state of intention of genocide. One aspect is the Israeli military using the AI technology called Lavender that identified 37,000 male targets in Gaza very soon after 7th of October. Many of you will know that the cell phone network in Gaza, as in the West Bank, is run by the Israelis, and the Israelis track people in Gaza via their cell phones, and they think they know who the people in their hand who are in Hamas at all levels, whether working as policemen, as cleaners, as mayors, or actually in the armed wing. They could quickly generate these targets because there was a political imperative to strike back. Now, the human operators spent 20 seconds per target to verify that they're male, because they said women can't be, by definition, in Hamas. And the settings allowed for 15 to 20 civilian deaths for low-level targets. But they were then killed with 2,000 dumb bombs that flattened entire buildings with the occupants inside, which vastly exceeded this ratio of 1 to 25 or 1 to 20. Because another software, which was called Where's Daddy, extremely cynical name, determined when the targets entered their homes, where the IDF preferred to bomb them, meaning that entire buildings with their female and child inhabitants, civilian inhabitants, were killed along with their target. Now, leaving aside the cavalier and imprecise manner in which these targets were determined, this practice puts paid to the stock defense of the high casualty rate, namely that they were human shields caused by Hamas hiding among civilians and making them therefore military targets. In fact, military operators waited until their targets were among civilians to launch the ordnance. These civilian deaths were not incidental. They were quite deliberate and cumulatively result in, if you like, genocidal outcomes, even if the legal nature of the term doesn't capture that. So what you have is this messy fusion of military and genocidal logics. And it's also evidence in the siege starvation of Gaza. Whereas the UN officials and academics have been warning about genocidal famine in Gaza for months, Israeli officials, their Western supporters, and the Israeli ad hoc judge at the ICJ, Aaron Barak, disavow a genocidal intention by insisting on the military context and its tragic byproducts. Meanwhile, senior Israeli figures claim the siege is not intended to starve the population, but to induce Hamas to end its resistance and release the Israeli hostages, as well as to induce the population to leave. You recall one of them said, once disease breaks out and it affects the children of Hamas, then they'll cough up the hostages. Giora Aylan said, this is not about cruelty. So an Israeli advisor to the former defense minister and former head of the Israeli National Security Council. He said, this is not about cruelty for cruelty's sake. Since we don't support the suffering of the other side as a goal, but as a means. Now, combined with statements about making Gaza uninhabitable, the effects on the Palestinian population in no way really can be seen to be incidental. They are intended. They are genocidal in effect, and their vehicle, though, is military necessity. Again, the military and genocidal logics are fused and commingled. Finally, there is a cynical use of humanitarian rhetoric about safe zones and passages, ostensibly to remove civilians from combat zones, but only to kill them en route, as well as aid workers through bombings. On the grounds, putatively, that Palestinian Hamas figures may be lurking there. I mean, it's always alleged, it's never proven, but it's alleged. Francesca Albanese calls this practice, this last practice, humanitarian camouflage. Cumulatively, these ostensibly legal and humanitarian gestures are having a genocidal effect. Taken with statements from Israeli leaders to depopulate northern Gaza, along with the destruction of schools, universities, mosques, hospitals, agricultural land, as well as buildings in general, whose rubble could take, till 2040 or 2050 to remove, it's impossible to avoid the conclusion that the effect, if not the point, of the military action is not solely to destroy Hamas, as claimed, but also the possibility of Palestinian life in Gaza. As I've mentioned, this is the conclusion of the pre-trial chamber of the ICC, when it concluded that when it improved the arrest warrants, most recently, for war crimes and crimes against humanity, the policy and practice could not be justified of siege by military necessity. And I quote it now. The chamber found reasonable grounds to believe that no clear military need or other justification under international humanitarian law could be identified for the restriction placed on access for humanitarian relief operations. So they're separating out the military from the criminal, in this case, war crimes and crimes against humanity. You have to bear in mind what they're buying into, as I have to as lawyers, is that killing all these civilians, if it's military, is okay. That's the secret that rarely speaks its name in international humanitarian law. Finishing up, this more radical aim cannot be detected, for example, in US policy and conduct in Vietnam, where there was no intent by the Americans to expel the Vietnamese and settle it with Americans and so on. Even so, despite all these things I've said, well, then conclude, the evidence out there, Karim Khan sought a warrant for Israeli leaders for the crime against humanity of extermination, not genocide, and he failed in that. And the pre-trial chamber did not approve the extermination element. Don't forget that it's based on evidence from May, right? So what's happened since May has not been taken into account for technical reasons by the pre-trial chamber. And I've been speaking to international legal friends about this, and they go, well, in May, the death toll was a lot lower, and you didn't know what was coming. The whole campaign in the north of Gaza hadn't happened yet. And they may have concluded that the element of mass exterminate, that you need the sort of mass killing for the crime of extermination, hadn't yet occurred. So, and you can't update these warrants. However, you can issue new warrants, and I'll get to that now. It did set the stage, however, the pre-trial chamber, for a new warrant of genocide by including language that mirrors Article 2C of the Genocide Convention here. Deliberately, so this is the Genocide Convention, right? Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction or whole or in part. Okay, so the Israeli authorities, said the ICC a week ago, on the basis of the situation of May 2024, said the chamber found that there are reasonable grounds to believe that the lack of food, water, electricity, and fuel, and specific medical supplies created conditions of life calculated to bring about the destruction of part of the civilian population of Gaza. Do you think that's an accident? Of course it's not. Right? They're setting a trigger that what's happened since May could be revisited, and if the ICC or the pre-trial chamber, in the event of a new application for warrant, concludes that there is an intent to destroy a group in whole or in part according to Article 2C, maybe they'll issue a new one. Now, until international courts are willing to recognize the fusion or commingling of genocidal, military, and now even humanitarian logics, prosecutors like him, like Khan, are unlikely, though, to try their luck with genocide. Remember the restrictions on inferring genocidal intent that I mentioned before. Has to be the only conclusion you can draw. Unless the ICJ gives a signal by updating its jurisprudence to reflect empirical reality. The unique modalities of the Israeli campaign afford these judges an opportunity to update the jurisprudence. So the world awaits their determination with great anticipation. Thank you.
Great, thank you. Let me pose the first question, then we'll open it up to the audience. Given what you've sort of argued and given your critique of this hierarchy of international law that elevates genocide to sort of the detriment of other people who are suffering, what advice would you give to Palestinian human rights activists today in light of the situation in Gaza in terms of where to direct their energies?
Well, I'm loath to give advice to, as a comfortable academic, to people who are desperate for something to happen. Now, there's a reason South Africa made the application for genocide in the ICJ, and it's one that indicates the path dependency of the way the law is structured. There is an international convention on genocide to which all these parties are subscribers or signatories, and previous jurisprudence at the ICJ allows third-party states to sue another state for not preventing genocide. That occurred in the Gambia case against Myanmar, where the Gambia is a state in Africa, obviously is not a party to the conflict or the situation in Myanmar. That's an internal armed conflict. But the ICJ ruled that genocide, by subscribing to the Genocide Convention, states have an obligation to prevent genocide, including in their own territory. And that's sort of a universal obligation that's owed to other states. It's sort of the fabric or tissue of humanity that binds us. It's that kind of thing. And, as opposed to, just putting down a little rebellion or something, right? If it sort of reaches the scale of genocide or where a plausible case can be made, then another state can actually take the state in question to sue them, to take them to court. Americans love suing, right? So it's that kind of thinking, well, I'm going to sue you. And even though their own rights have not been affected. Now, the ICJ allows states to sue other states, where the ICC deals with individual perpetrators. And only the ICC can initiate those prosecutions. Okay, the Karim Khan has to be convinced that there's a case, then he applies to the pre-trial chamber. They have to be then convinced, and then individuals are charged, not states. Okay, so with the ICC, there's no agency possibility for Palestinian activists, right? They can't initiate anything. Right. But, South Africa took the bull by the horns here. Not an Arab state, mind you, it was South Africa, right? It doesn't have clean hands itself. Bashir from Sudan was there at some point, and they didn't arrest him. They should have. Right. Okay, so none of these states are heroes. But South Africa is sort of widely hailed now in the global South for having done this. But this was the only option. If there was a convention on crimes against humanity, which is being negotiated or debated right now, okay, South Africa or another state could have gone through that route, and we would be discussing crimes against humanity, which is, not easy to prove, but easier. Okay, so that's one alternative. That is, the Palestinians have no other alternative via the ICJ, but that South Africa is driving that, not Palestinian activists, right? Now, my cautionary note is, I acknowledge, as you say, that there are rules of the recognition game, which I don't like these rules. This fetish of genocide, because crimes against humanity is a terrible crime. It's one of the grave breaches there are grave breaches of the Geneva Conventions. And let's not forget, as I said before, in the Nuremberg trials, where crimes against humanity and war crimes, along with the crimes against peace or the crime of aggression, were the three main indictments. Calling Hitler a war criminal was the ultimate stigma. You didn't need to have recourse to genocide. The word existed at the time, but it didn't have the status that it does in international society. So we can see that these things change, right? As we're scholars, languages of transgression, which is a subtitle of my book, wax and wane, will they develop? Right? Maybe calling someone something else in a few years, like someone who commits apartheid, an occupier. It shows you how uneven or segmented these languages are as well. I mean, if you come from a situation where your people have been colonized or occupied, whether Palestinians, indigenous people, what have you, to call someone an occupier, is a serious indictment. But, I don't think many people in Europe would care. Or here, you call me an occupier, who cares, right? Whereas, so it's very much context specific, right? My word of caution would be, what's plan B if the ICJ doesn't rise to the occasion and develop the jurisprudence on international law and says, like the ICC, we don't see a genocide here, we see other crimes. There are crimes here, but other crimes, right? What then? Well, what you'll see is that Israel's backers will say, told you so.
Yeah, we won.
We won. This is an armed conflict. Yeah, maybe there are a few, missiles that we should have not have fired. Maybe they were mistakes. When that convoy of aid workers, remember the Food of Life tree? What was it? Yeah. There was an Australian among them, so obviously this was big in Australia. What happened? Oh, some operators got it wrong. Somebody lost their job. And then the anguished Western support of Israel, who are under pressure from their media and domestic population, could quickly move on. And does anyone even talk about this anymore? I mean, it's outlandish, because they'd been warned many times or informed that, a convoy of aid workers is coming. Now, so what's plan B? Okay. So the UN has come up with this notion of atrocity crimes, which bundles war crimes, crimes against humanity, ethnic cleansing, and genocide as terrible atrocity crimes. It has a rapporteur to this end, and the logic is that each of these is very difficult to determine and prove as they're unfolding, because in each of them concern acts which could refer to any of them. Ethnic cleansing can be part of a genocidal policy, or a war crime, or crime against humanity, right? But it's only years later, if and when the courts get to it, that it's going to be one or the other, right? But in the meantime, there needs something to happen. So if there's an atrocity crime alert, as it were, the R2P mechanism could be triggered, right? So it's a way of sort of broadening our horizon. But, the atrocity crimes, does that language, does that slogan have any traction in the media? Not really, right? So this is why victim groups, especially smaller nations that are powerless, right, are stuck and cornered by this language and legal regime which has developed since the Second World War. It's actually a conspiracy against them in many ways. It's not a plot or conspiracy, but it's worked out that way. Right? The nation states of the world developed this in the late 40s to protect themselves against people like that. Okay. And we're seeing the outcome of it now.
Yeah, good. Okay, 1, 2, and then at the back, 3. Go ahead.
Dirk, thank you so much for coming to us today and giving us this brilliant, incisive analysis. But I would suggest, I'm Michael David Fox. I'm a professor of Russian Soviet history and director of emergent studies here. And having spent 10 years studying the war on the Eastern Front, I would suggest that this fusion that you're talking about between war crimes and crimes of genocidal intent and crimes against humanity, for that matter, is not novel to Gaza, but was implicit in the original case that you are analyzing through legal and intellectual currents. But I want to call your attention to the destruction of up to 3.3 million Soviet prisoners of war, which could not be called genocidal because it was not systematically trying to destroy them. And it was also recruiting many for the war purposes of prosecuting the war. They were recruitment camps as well as extermination camps. But I would suggest, when I was studying this for 10 years, I had hundreds of brilliant books written by some of the finest minds in the historical profession on the Holocaust in the East. And in the East, on Soviet territory, the number of Jewish victims was less far less than, significantly less than 3.3 million. But I could rely on 0 monographs in the English language about this war crime of genocidal proportions, as I called it. I wish I had read your book before I finished mine, but what I'm trying to suggest is that the distinction you've made here between historians on the one hand and sort of the jurists and political politicians is in some sense artificial.
Yeah, thank you for sharing that. That's a very important point. And Lemkin was blind to that himself. So while we've got a Russian expert, I was wondering if I could ask you, Michael, this question. As you know, last year or the year before, a St. Petersburg court determined that the German-led siege of Leningrad was an act of genocide against the sort of the Soviet people. Now, this is to some extent, or maybe to a large extent, a product of the current conflict with the West, because the way this decision has been received and maybe driven by is the perception that the range of forces led by the Germans in the early 40s against this city, which included Finnish, French, and other, in SS, these sort of foreign SS divisions, right, roughly mirrors NATO forces. So what the Russians are arguing is that NATO was on our doorsteps committing genocide against us, led by the Nazis in the early 40s. And now it's those Nazis in Ukraine that they're defending. And, if we don't stop them here, they'll be at our throats again. And it's a genocidal attack. So I was wondering if, what you mean.
It's part of what I said, and I'll just be very brief. They've decided to also look at the POWs now in that light. This was always covered up by Stalin because it showed Soviet weakness that there was such destruction. And it was silenced for the duration of the Soviet period because you had a controlled historical profession. But after 91 now, you have post-Soviet Russia engaging what I would call in historical politics with Germany and Israel because they shared the Holocaust and it was very effective internationally. So now you're seeing the same logic that you're talking about, essentially playing the genocide card by Russia, but with exactly the same intent for current political purposes.
Thank you.
Thank you.
Go ahead.
Thank you very much for your comments. I remember during the time of the U.S. war in Vietnam, it was said with acceptance, it's the first televised war, and now we're live streaming genocide. So I appreciate your broader definition of it and sort of want to push it a little further. I spent a couple of weeks in the West Bank in May, due to go back in January. 2 or 3 things that I learned in May. The IDF targets pregnant women, and they call it a twofer. Most people think that Blinken is Netanyahu's personal defense attorney, but all over the West Bank is Genocide Joe. Given your broader definition,
People are saying that there, or you're seeing that written, or
posters. I have posters of Genocide Joe that are from the West Bank.
Who put them up, by the way?
The Palestinians.
Oh, I see. Okay,
Well,
right.
Yeah. So the point is, given the broader definition of genocide and who can be complicit, why wasn't Biden issued an arrest warrant? Why isn't the United States also complicit in this genocide that it supports, and without its support, it would no longer continue?
Well, from colleagues of mine who work closely on the ICC, and some of them have worked in the ICC, in previous iterations with different prosecutors, its decisions are also politically weighed. Now, you've seen the resistance or reaction to the ICC's indictments or warrants a week or so ago in the US press and among US politicians, because Israel is a US ally. What do you think would happen if US figures were themselves indicted or issued a warrant?
Maybe we would stop sending supplies.
No, maybe the ICC would cease to exist, right? So, but there might be technical jurisdictional issues that I'm not qualified to say, right? So, no, but I follow the German press because I work on Germany, among other things. And now people in Germany are wondering, well, we're the second largest arms supplier. will this warrant affect what we do now? Because, you know, are we, you know, if we keep sending arms in these circumstances, then are we now running the risk of, you know, because the German take the ICC it's one of the biggest supporters of the ICC. Of course, there's politicians saying, you know, down with the similar to you, down with the ICC, this isn't serious and so forth. But, you know, the legacy of Nuremberg, which the ICC crystallizes or represents, is deeply embedded in their political culture. And so, you know, in the end, it'll be interesting to see where they land on that.
And the United States statement about humanitarian aid, now it's okay, you know, for the 30-day period, that's also just, you know, not true and deceitful and malicious as well. Excuse me.
I can't comment. I'm not a citizen here, so I can't comment on these things.
You're next.
Yeah.
Go ahead. Yeah, go ahead.
Thank you for coming to Georgetown today. I'm a second year student at Genocide at Georgetown, and I wanted to ask you a follow-up question with response to SEC's arrest warrant and against Israeli leaders. So many Republicans are now talking about sanctioning SEC. And do you think that will actually going to happen? And how serious the sanction would be? Would it be something that's going to totally pulse the operation of ICC? And what does it mean to the international order rule?
Yeah, I mean, I can't speculate. I mean, you're asking me to speculate, so I can't give you a definitive answer. But, you know, they will have gamed this out, because they know that the previous prosecutor was treated in this way. And there have been reports that certain security services spied on her office and death threats were made and so forth. I mean, look, sovereign interests are at stake here. And when states feel that their sovereign interests are at stake, they will stop at nothing. And putting pressure on some court is for them. For states that can blow up people in other countries with secret weapons, you know, little exploding gadgets, putting pressure on some lawyers is not very hard, right? Now, they will be anticipating this, but I imagine they realize that bridges will be burnt with people in the West. But they also know that, as many of you, that there is ongoing chatter globally that the ICC is biased against particularly African leaders. And if the ICC had not done this, its credibility outside the West would have been utterly smashed, would be the end of the ICC. So they've taken a calculated risk, and in the end, you know, China, Russia, and America, along with Israel, Myanmar, many other states, are not parties. I don't think India is either. Are not parties to the Rome Statute. So they can't stop it. They can jump up and down and make threats, but they can't actually stop proceedings, at least legally.
Here's a question from our online audience. How can we verify what is actually true? Journalist access into Gaza are unlikely to hold Hamas accountable due to either their ideological leanings or the political environment. The Israeli media is dubious for the same reasons. The IDF gives guided tours for independent media, which obviously will be very selective. How can we ever get a clear picture of what is going on in Gaza, given these limitations?
Yes. So that's a very good question. I mean, it's very disappointing that journalists aren't allowed in, and the Palestinians ones who are there are killed, seemingly systematically. Right. It's amazing how consistent the targeting is. If it's an accident, it's an amazing coincidence. And at the same time, there seems to be a consensus that the statistics from the Gazan Ministry of Health are reasonably solid, although they don't distinguish between Hamas and non-Hamas fighters, okay? If anything, they're an undercount. Now, that's the death toll. In terms of the other types of destruction we've been talking about, for example, the forensic architecture, cartography of genocide, you know, they have all kinds of technological means of accessing that information. In terms of the starvation, there are international observers on the border counting trucks that are going in,
Right.
and they're in touch with people on the inside. I mean, clearly there are aid workers there. They're the ones that get killed. Okay, so it's not as if it's hermetically sealed. Okay, but the full extent of the damage is clearly not yet visible.
We have a lot of doctors who've given testimony,
Yes.
right? Who've gone in and have eyewitness accounts.
American nurses,
Yeah.
doctors who appear then on morning TV,
Right.
and tell us what's going on.
Let's take 3 more questions and then we'll start to wrap up. Very back, 1, 2, and then Fidat.
I really just want to ask you what next, but it's a little much of a question, so I'll just ask your thoughts on UNRWA's or Israel's recent actions against UNRWA and kind of how you see that.
Right. Okay. So the question was, what's next in relation to the criminalization of UNRWA? So it's a good way to virtually end the discussion. What we're witnessing is the ethnic cleansing of northern Gaza, the building of a corridor there, a buffer zone to the south, the corralling of the Palestinian population into the south. The likely plans are afoot for the resettlement of the north, and we're going to see a version of that. So you asked me what's next. I'm extremely pessimistic, right? We're going to see a resettlement, so a version of that in the West Bank, with the annexation of Area C, the ethnic cleansing of Area C Palestinians, corralling them into ever smaller parts of the West Bank, and then the conquest and settlement of those areas in the West Bank as well. So unlike the Nakba and the Naksa, the borders are closed, and the Israelis can't push them into the desert like the Armenians were pushed into the desert in 1915. Very similar patterns, by the way, to 1915 in the Armenian genocide. But there, you just push people into the desert. That's why you have such large Armenian populations in Beirut and in very good restaurants. I've been there a few times, and in the Armenian quarters, and in Damascus. Some people made it out the other side. Now, I wrote this article. I had it up there briefly in the Boston Review over a year ago. Well, I kind of predicted this. I said they're going to corral people into these unsustainable situations, take over the rest of the land, because there's a big push for the resettlement. Because in the settlement movement in Israel, and don't forget that faction is in the government, right? The Ariel Sharon's withdrawal in 2005 was seen as an historic mistake. So they want to rectify that. Right? Now, they can't deport these people, Palestinians, but they can corral them into smaller spaces and create impossible situations. Okay. And the wager, I said a year ago, is that although the international community is not, especially Arab states, are not inclined to do anything, the weight of public opinion, say at the end of next year, the year after, will be such that their governments will be forced to act and take them. I mean, we know that Lemkin did a tour of the local capitals in late October, so a year ago, less than a year ago, 13 months ago, to see if they would take Palestinians. And they said, no way. And we had Israeli ministers on TV saying, Canada could take a few 100,000. Why wouldn't you want to live in Canada? Rather, who wants to live in Gaza after we've destroyed it, right? So just to make it other people's problems. But, Arab states have learned, they're not going to take them back, right? And I ask myself and Israeli friends who are anguished, why can't Egypt just take them for a while? And I go, do you think Israel's going to take them back? And anyway, most of them are refugees from what's Israel today. Why don't you take them? Why don't you put them in camps across the border until Gaza is rebuilt? And the fact that that's unthinkable for them gives you a sense of where this is going to land. So I think this is going to get worse for the people living there, and that the region will be destabilized by this. And this is the outcome of a policy of supporting, if you like, permanent security aspirations by is not a regular Israeli government, right? If Yair Lapid was in government, I'm sure it may have landed slightly different. There may have been, pulling back from the brink, but that's not the situation. Does that make sense? So I have no grounds for optimism. Yeah, but once again, whether genocide is the right concept, legally creating conditions, and that possibly. But I think it's more interesting to step back and look, what is the strategic logic here on the part of the Israelis, and what are the likely scenarios, and then we can talk about doing the best for the civilian population.
For that,
Do you have time for that?
yeah.
That was very pessimistic, and I wanted to talk about something that you said that was maybe more optimistic, or maybe that's not. You talked about this artificial binary between war and genocide, and how what's happening right now in this war on Gaza might provide a model for rethinking that binary. What would that look like to make that happen, and how?
Although I don't like the Genocide Convention, we are stuck with it. It's international law. I think there should be an invention on crimes against humanity and against what I call permanent security, right? But it doesn't exist. So we have to work with the law that we have. And, these judges, don't sit around like academics and have wishful thinking. They're not, here is the law. It's black letter law. Here is the law. Here are the circumstances. Does it fit in the box? It's that simple, okay? Now, but jurisprudence is also dynamic. Supreme Court here innovates, it de-innovates as well in certain circumstances that we see. It can go backwards, but it can be, an argument can be made by South Africa's lawyers that it's inaccurate to try, or it makes no sense to look for a single inference that could only be genocide. As I pointed out in the slide, right? That in fact, genocide is fused with military logics, as I was discussing with Michael, right? And that this distinction between armed conflict or military logics and genocidal logics, this hard distinction, makes no sense. It's in a sense almost a philosophical rethinking or epistemological question. And if they can get that through their black letter heads, they might be able to innovate. And lawyers or judges do that. And my understanding is the ICJ is not bound in any hard sense by even the doctrine of precedent, although they don't like to reason outside the doctrine of precedent. They can do what they want.
One final question about Raphael Lemkin, because I don't know anyone who's read his entire collected writings, both published and unpublished, as closely as you have. So he was the founder of the field of genocide studies. He was also a Zionist, and he dies 10 years after the 1948 Nakba. Is there any indication of a recognition that what happened in 48 was something ugly? If it wasn't genocide, it was certainly in the tradition of something that he studied as a colonial settler, sort of, imposition against the rights of the indigenous population, which is part of his writing. But so how did he reconcile his own personal political convictions with his scholarship?
So I've not found any papers in his oeuvre, where they're spread around various archives in New York and in Cincinnati. Jim Leflow, who I mentioned before, teaches, he was at UVA, now he's, I think, at Hopkins here and nearby. He's writing about that. And Jim reads Hebrew and Yiddish, and the languages that Lemkin wrote in and read. Lemkin was knew all kinds of language, very talented. And he's investigating that very issue. My sense is that Lemkin would have seen Israel, the founding of the state of Israel, as a very much from the Israeli point of view. But he kept in, he kept in touch with scholars there and so forth. He downplayed his youthful Zionism. He never gave it up, but he downplayed it in his public persona in the 30s and 40s. In order to create genocide, propose it as sort of a cosmopolitan, universalistic concept that applies to everyone, and is not a vehicle for any particular interest. So, but I do think he may have been flummoxed by this case.
Right.
Though he, to his credit, he aided the Algerian National Liberation Movement. He was in consultation with them. And I learned from a historian of German Southwest Africa in Namibia the other day, Fabian Krautwald, that he actually worked with the Herero activists in the 50s seeking recognition for the genocide of before the First World War. So, and then he wrote this little global history of genocide, which was never published. But most of the chapters, which I've read and they've got the manuscripts, are about colonial imperial cases, even within Europe, because that's the context in which genocide occurs. So, you know, I've written about that in various contexts. Yeah.
Dirk, your big book is called The Problems of Genocide, and you've certainly helped us think through some of those problems in the context of what's happening in Gaza today. So thank you for being here, and I ask the audience to join me in thanking you.
Thank you.